him, we would ask that Your Honor consider removing the tether.
Prosecutor?
Your Honor, people at this time feel that the bond, as currently set, is reasonable and would object to any alterations at this time, Your Honor.
Okay, your client is out of custody, correct?
That is correct, Judge.
Okay. And let's see. Carrying and conceal possession of bond. At this time, the bond, the tether provision will remain. Obviously, Mr. Reeves, on February 13, when you come back for your exam, this issue can be readdressed at that time, or case may not move forward. So bond will continue with all provisions as of right now. Thank you very much.
Thank you, Your Honor. Have a great day.
Okay, you also. Are we ready on Nickerson?
Your Honor, I don't have a.
Jonathan Roberts, it says he's here for Richard Nickerson. Is that, yeah.
He hasn't communicated with me yet, counsel. I've asked him to unmute, but hopefully he will now, Judge.
Okay. Mr. Nickerson, we see you. Just hold tight. We see you.
Good morning.
Morning.
I have Mr. Richard Nickerson for you.
Yes, we're waiting for his attorney to unmute. He's in the Zoom room, but we're waiting for him to unmute. Then we're going to call the case.
Okay, thank you.
Thank you. Mr. Roberts, are you ready on Nick?
Yes, Your Honor. Apologies. I was in another courtroom.
It's okay. It's okay.
If actually I could get a breakout room with Mr. Nickerson, this will be my first time speaking with him, and I want to make sure to introduce myself.
Okay. Would you like that before or after the PCC?
Could we do that before, just so I can make sure that he knows everything that's going on? Thank you.
Yes. All right, Serena, can you establish a breakout room? Sir, join the breakout room.
My lawyer wanted to.
They never sent out subpoenas, and it's a real serious case. Since the judge is on Zoom, should I just do a quick email to you? What's the best way?
Your Honor,
Yes.
this is Dave Parrish. My apologies. This morning was brought to my attention. I was in contact with an OIC for one of our cases that is scheduled for an examination at 10 a.m. Versus defendant Timmons. Subpoenas, yesterday it was brought to my attention that subpoenas never went out. So I tried to rectify the situation yesterday by sending new subpoenas out to the OIC, but due to the snowstorm, he was not able to deliver these subpoenas. And due to the fact that this was scheduled weeks ago, I'm assuming I was not the prosecutor at the PCC, but I'm assuming that there was just an error, a clerical error or some kind of error with their new system, but subpoenas did not go out. And these are very serious charges. I was hoping to get an adjournment for 10 days just so that we could set a new date and have the officers actually go out and subpoena the witnesses.
That's an argument that you need to make on the record with
Okay.
when that case is called.
Can I do that? Is that okay if we do that at 10 o'clock when that happens, or should I send out an email to the defense counsel? I usually don't do this last minute, Your Honor, so whatever's best for you.
That's yeah, I mean, this is going to be your motion. This matter is set for an exam at 10 a.m. and I'm expecting the exam to go forward. So if you have something that's going to go contrary, that'll be up to you. But at 10 o'clock, the case is going to be called. If you
Okay.
work with the defense and the defendant to have the case called before, we'll be ready to go whenever you're ready. But I can't really give you instruction on how to move forward with that.
Okay, Your Honor, thank you.
No problem. No problem.
That's okay.
I think all of these are supposed to go to Judge Williams. Okay. Just wanted to check. Snowstorm chamber, right?
Serena, I'm sorry, Madam Clerk.
Yes,
Any word on the attorney for Isom?
Your Honor, no, but, for the report, that particular report will not be ready until another 60 days. So, I could give her a call. Should I
Yeah,
do that?
please.
Okay.
And so we just need to adjourn it out, so.
Thank you for calling the
Mr. Mitchum, can you hear me? I guess not.
Mr. Mitchell, you're gonna have to remove your hood. Mr. Mitchell?
Okay, Mr. Mitchum, work on your sound. You gotta work on your art. There you go. There you go. Mr. Mitchum, can you hear us now?
Yes, I'm sorry. I apologize.
No problem. Pull your hood down. And send your attorney a text and let him know if he gets in here a little earlier, we can get the case going.
Okay.
All right, thank you. Mute yourself. All right, please call Nickerson.
All right, yes, sir.
Calling case number 2055147, the people of the state of Michigan versus Richard Lee Nickerson. The defendant is charged with 1 count stolen property, receiving and concealing motor vehicle. The defendant is a habitual offender, third offense notice.
Good morning, Daniela Parrish on behalf of the people, P85495.
And good morning, Your Honor. Good morning, Madam Clerk Jonathan Roberts, P86428, on behalf of Mr. Richard Nickerson. Mr. Nickerson, could you please state your name for the court?
Richard Lee Nickerson.
Okay. Today's the date and time set for a probable cause conference. Councils, are there any issues with discovery or any issues that we need to discuss at this time?
We are prepared to move forward, Your Honor, to exam. If we could also get, if possible, a bond redetermination hearing set.
We'll address bond right now, but is there anything else besides a bond hearing that you need in this matter before we set it for an exam?
No, not.
Madam Clerk, exam date.
February 13th at 9:30.
February 13, 9:30 a.m. Does that work, Mr. Roberts?
Yes, that works, Your Honor.
Okay, as to bond, councils. What is bond currently set at?
I believe it is.
Your Honor, if I may, it's $1,000 cash or surety.
Okay. Okay.
I would ask, Your Honor, that bond be set to a nominal amount. Mr. Nickerson would not be able to pay or have someone be able to pay for his release. I believe that given the circumstances of this case and given Mr. Nickerson's record, there's nothing to suggest that he's a danger to the community. There's nothing to suggest that he would not be able to come to upcoming and succeeding court dates. I'd also note that Mr. Nickerson has mentioned to me that he would want to get out so that he can take care of his grandmother. He has family ties in the community. I do believe that ultimately bond should not be a punishment for people who just can't afford to pay something. I think bond must be a careful determination of who is this person in front of us, what risk do they have to the community? I don't see that in Mr. Nickerson. He is 53 years old. I don't think that there's going to be issues if we set this bond at a nominal rate.
Madam Prosecutor, argument.
Thank you, Your Honor. I disagree with defense due to the fact that this bond was already lowered at one time, and after it was lowered, the defendant actually did fail to appear once it was lowered to a personal bond. So the people believe at this time that the bond is more than reasonable, and due to its capious nature, we feel that the bond should not be reduced at this time, and that it is set reasonably for defendant's record of capious.
Hold on, Mr. Nickerson. Counsel, when was there a capious in this matter?
Your Honor.
Oh, okay, Madam Prosecutor, if you got it, yeah, go ahead.
Yes, Your Honor. Bond was initially set at $5,000 back in January 2020. After that, the bond was reduced in December of 2020, or excuse me, it was reduced, let me make sure I get the right date, January 4th, 2021, to a personal bond of $500. And then after that, ROA indicates that the defendant failed to appear in May of 2021, where the bond was then set to, it was increased, obviously, due to the capious nature. So, and this leaves us here today.
And so when did okay, and so that was in 2021. When was the next arraignment or the next hearing?
Next arraignment, Your Honor, it appears. There's a few dates here, Your Honor. I just don't want to give you the wrong time. You get a pre-trial. It appears in May of 2021, Your Honor, and we did not come till just now, till this January 18th, 2023, where the bond was set again.
Okay, well, I guess my question was between 21 and right now. How long has he been in custody, and how did we get back here?
I think he was in custody, unless defense has more information for me. According to the ROA, he's been out with capious for almost 2 years.
I would note, Your Honor, that Mr. Nickerson has been homeless for much of this time. And I certainly understand Ms. Parrich's position about if we reduce bond, will he come back? I think the problem ultimately is that in 2020, 2021, Mr. Nickerson was not provided support. And to say that because someone is experiencing houselessness, homelessness, and obviously, Your Honor, I think we recognize that presents a barrier to coming to court. In DS Detroit, since 2021, we have built up our own social services network. I think Mr. Nickerson deserves support. I don't think he should be reprimanded for his socioeconomic position. I don't think he should be reprimanded.
All right, and Mr. Roberts, I'm going to cut you off for 1 second, and I appreciate that. But my question is, how did we get back to here? Did he walk in? Was he picked up on something? If he was out for an extended amount of time on a capious, how did we do we have any idea how we got back here?
Can I ask something?
Go ahead, Mr. Nickerson. If you
Yes, I was picked up, sir. I was with a friend. I'm not gonna sit here and sugarcoat anything to you, sir.
Okay. You were picked up. That's all I need to know. I don't want to know. Okay.
But yes,
All right.
I am.
Okay, sir. That's all. I just wanted to know how we got back here.
Yes, sir.
Court having heard the arguments of both counsel and Mr. Nickerson very, very quickly. The court obviously is going to take into account multiple things. The nature of the offense is a nonviolent offense. So threat to society, the court doesn't find that Mr. Nickerson is a threat. The issue is whether Mr. Nickerson is going to appear for his, sir. If Mr. Nickerson is going to appear for his February 13, 9:30 a.m. Preliminary exam. the court is going to defer to the arguments of Attorney Roberts that NDS is going to provide some services, make sure that he is here. We're going to try this one more time. So we're going to lower the bond to 1,000 personal. Mr. Nickerson, we're not doing this again. If you don't show up for court, the next time you get picked up or whenever, there will not be any lowering of bonds. You're gonna have to stay until this case is resolved. So we're gonna give you one more bite at the apple. We're gonna trust that you and your attorney are gonna do what you say you're gonna do, and you'll be in front of Judge Sabri February 13th at 9:30 a.m. So the bond is gonna be reduced to 1,000 personal. Thank you.
Thank you.
And Your Honor, if I could get one more breakout room with Mr. Nickerson, thank
And
you.
Mr. Roberts, please stress. I mean, he's celebrating now, but it's gonna, it's gonna be an issue
Yes.
if he violates this. So, all right, thank you very much, sir.
Thank you.
Good luck, Mr. Nickerson.
Hey,
All right.
thank you, sir.
Good.
Thank you, Your Honor.
You're welcome. Madam Clerk, can you call the Tony Mitchum case, please?
Yes, Your Honor. Calling case number 2056017001
I
of the
need
state of
to
Michigan
break out room.
The people of the state of Michigan versus Tony Ethan Mitchum. Defendant is charged with one count of malicious destruction of personal property, 1,000 or more, but less than 20,000.
Good morning, Your Honor. Daniela Parrish on behalf of the people, P85495.
Breakout room.
Good morning, Your Honor. Max Manugian, P76341, appearing on behalf of Tony Mitchum.
Okay. Mr. Mitchum, state your name for the record. Take yourself off mute and sit up.
I'm sorry about that, Judge. Tony Mitchell.
Okay. Today's date and time set for preliminary examination. How are we proceeding?
Your Honor, I found out this morning that Mr. Mitchum had tested positive for COVID yesterday. So we may need a new date. I would be willing to proceed over Zoom if the people would consent to that. But obviously he can't come into the courthouse.
Madam Prosecutor, any objection to proceeding over Zoom?
Your Honor, the people do have witnesses here. I just would need a few moments to speak to witnesses to explain the procedures of what's going to take place since it would transpire via Zoom. People do not have objections to that. If they are holding the Zoom today, if they prefer, I don't object. I just have to check if my witness can return. If there is an objection, or excuse me, a preference for an adjournment, but we would ask that it just be.
Well, madam, this is not a preference for the witnesses.
I'm
I'm just letting you know the defendant has the right to confrontation and all that good stuff. But so
Right.
if you would like to return, I mean, we can adjourn it out, but the court has no objection to proceeding right now via Zoom with the defendant based on his health issue.
Correct. No, and I apologize for the misunderstanding, Your Honor. I was going to say if we were going to adjourn it out, I would just wanted to make sure that the date that our witnesses can return so that we don't have another adjournment.
Okay, and I'm saying I'm not looking to adjourn it out. So if you don't want to adjourn it out, just call your first witness. We can call the case and we can go.
That's fine. Either way, the people have no objection to either one, Your Honor.
Okay, call the case, Madam Clerk. Oh, we already called the case. All right, call your first witness.
Your Honor, I apologize. If you just give the people, I know it's scheduled for 9:30. If you just give the people a few minutes so that I can go out and actually speak to our witnesses that are in the hallway. Do we need to call any other cases prior to the 9:30 exam?
We got nothing ready besides that. Okay.
Okay, Your
go
Honor.
ahead.
Can
Well,
I have a few minutes?
yes.
Thank you, Your Honor.
Okay.
Which one?
And Judge, I'm gonna log back on my computer.
Okay.
Thank you again, Your Honor. Are you good with Mr. Nickerson?
Come on. There you go. Thank you. Yes, I am. Thank you very much, Sheriff.
Blessed day.
Okay, you also.
Yes, good morning, officer. I am here on
Max, there you go.
Good morning.
Good morning, Attorney Diallo. How are you?
I'm good. How are you?
I am excellent. You
I
weren't
see my-
expecting me. You weren't expecting me, were you?
No, I wasn't expecting you, and I wasn't expecting my client to be on Zoom, but that's okay.
Yes.
We'll be okay.
Yeah. The prosecutor just stepped in the hallway to speak to a witness. As soon as she comes back, I'll call the case. It's my understanding that the report is not ready and they need another 60 days. So
I think we already had a competency issue. So if it's set for competency there, that's fine because we got one for the Third Circuit. But if they don't have one ready for this one, we'll just defer.
okay. All right.
Thank
So
you.
we'll call them when we
Oh, I didn't come through the snow. Wet ice, I came through. Instead of going about 50. God's grace.
Court officer,
Sir.
go get the prosecutor.
Yes, sir.
Thank you.
He's on the way, sir.
Okay, thank you. Attorney Diallo, are you ready?
I'm ready, Judge.
Okay, as soon as the
Even though you
prosecutor
can't
steps
see me.
in, as soon as she steps in, we're gonna call your case.
Okay, thank you.
All right, Madam Clerk,
Yes, Your Honor.
get the item case ready, please.
In my hand, Judge McConnell.
I felt it. I just couldn't see it. All right, call it, please.
Okay, calling case number 2258501, the people of the state of Michigan versus David Isom. The defendant is charged with count 1 police officer assaulting, resisting, and obstructing. The defendant is a habitual offender, fourth offense notice.
Okay, Madam Prosecutor.
I apologize, Your Honor. I couldn't hear the clerk.
Isom.
Thank you, Your Honor. Danielle,
Yes.
people P85495.
And good morning to you and your staff, Lillian Diallo, P52036, on behalf of David Isom, who is present via Zoom.
Mr. Isom, state your name, please.
David Isom.
Okay, today is the date and time set for a competency hearing. Have the attorneys had a chance to read or see the report?
So not on this particular case, Judge. I don't have that report.
Okay.
Unless Madam Prosecutor has it. If she does, we can set it for an exam.
Madam Prosecutor?
Your Honor, people do not have a report, but if the defense is asking for exam, I'm assuming that they are indicating that the defendant is competent. I don't have a report.
Well, then let's just set it for another competency hearing.
Okay, Madam Clerk, what is there is a report back in the file?
Judge, a request for a report was submitted on December the 7th. Apparently it takes 90 days for it to be processed.
Okay.
Oh.
So we don't have a report yet. So we need to push this back approximately 60 days for competency. Can you give me a date out around 60 days, Madam Clerk?
March 27th, 2023 at 9 a.m.
That
March,
works.
March 27, what time?
At 9 a.m., Your Honor.
9 a.m. Okay, thank you very much.
Thank you. Everybody have a great day. Take
You
care. I'll
also.
talk to you, Mr. Isom. Bye.
Okay,
March 27, Mr. Isom.
March 27th at 9 o'clock.
Yes, sir.
Okay, thank you.
You're welcome.
All right, good day.
All right.
Shit.
Okay. Who? Log off, Mr. Isom. Watch your mouth. All right. Yeah. We got you, Mr. Isom. You good. All right. Mr. Manugian, are you ready?
Ready to go, Your Honor.
Okay, Ms. Howell, is your client present?
No, Judge, I was gonna ask to waive his appearance. I'm here for a competency.
Okay, call the competency real quick. That's on Anderson.
Case number 2257719, the people of the state of Michigan versus D'Angelo Anderson. The defendant is charged with count 1, home invasion, first degree. Count 2, breaking and entering illegal entry. The defendant is a habitual offender, third offense notice.
Madam Prosecutor.
Good morning, Your Honor. Danielle Parrish on behalf of the people, PA 5495.
And good morning, Your Honor. Tiffany Howe on behalf of Mr. D'Angelo Anderson, P79667. My client is not present and I'm asking to waive his appearance for purposes of this competency hearing.
Any objection?
No objection, Your Honor.
Okay. Appearance will be waived. Are the attorneys in receipt of a report yet?
No, Judge, the defense has not received one.
Okay, Madam Clerk, is there a report or do we need another date on this case also?
Judge, it's much like the one before. It needs some more time. It was submitted on December 1st, Your Honor.
Okay, this matter will be adjourned. The report, sorry.
Well, Judge, I'm sorry to interrupt. This matter, we have been waiting for this competency hearing since the summertime, since August. We have been waiting several months. Judge Williams has ordered the report several times. He's called, and we just do not know what the issue is. I know my client was interviewed. However, he still has not received the report yet. And at this point, this case is I know he has another federal case, but he has since resolved his federal probation violation. And this case is the only case that's pending now. I'm looking at the register of action right now, and I'm at August 18th, 2022, in which we had another hearing scheduled where we did not have the report. And we were still waiting back in August. When I go back further to May, May of 2022, we did not have the report, and it wasn't complete.
Well, Ms. Attorney Howe, what are you asking for then? Are you asking to go to exam without the report, or you're not? I mean, the court is not going to dismiss the matter because the report's not ready. So what's your remedy right now?
Is it possible to do a show cause as to why this report has not been completed yet? My client is ready to move forward. We are ready to hold this exam and to get some type of resolution for Mr. Anderson. His life is in limbo right now because this report still is not ready yet. And I just don't understand.
Okay, what we'll do, anything, Madam Prosecutor, to this?
Your Honor, I'm in agreement with Ms. Howell actually on this. I was reviewing the file, wondering why it's taking so long. I was not a prosecutor in this courtroom at the time. However, the notes do indicate that they have come forward a few times. If you would like to, and I don't know if this would be a temporary remedy. However, if we could adjourn this out 2 weeks, I could actually reach out. This is nothing that we, the people, are actually able to do, but I have in the past reached out and asked them for some explanation of delays, and they have provided us with that, and sometimes been able to email reports over to the court. I do not know if that could happen in this case, but maybe if we just pushed it out only 2 weeks as opposed to 2 months or whatnot, maybe we can get a resolution by then, and I'm happy to reach out to the DHHS to see if they have a report ready. If not, why? What's going on here?
Well, Madam Prosecutor, I was actually leaning that way. The matter is going to be adjourned to February 13 at 9 a.m. Please reach out. I'm going to make a note for Judge Sabri also to see if there's anything that she can do to see what is the delay. We'll come back February 13 at 9 a.m. for resolution on the competency hearing.
Thank you.
Thank you.
Thank you, Madam Prosecutor.
No problem. Thank you.
Okay. Back on the record on, have a good day, Attorney Howe.
You too, Judge.
Back on the record of Tony Mitchum. Are there any preliminary matters?
Not from the people, Your Honor.
Nothing for the defense, Your Honor.
Okay. Madam Prosecutor, call your first witness.
Thank you, Your Honor. The people call Brianna Womack.
Here. Right here. Please raise your right hand. Do you swear affirm to tell the truth and nothing but the truth, so help you God? Yes. You may be seated.
All right. Your witness.
This one. Your Honor, they're putting her information on the record while she takes a stand.
Okay.
Ms. Womack, there's a mic right in front of you. You can move it. It's movable. Just speak clearly into the mic. If there's something that I ask that you do not understand, please stop me. I'm happy to rephrase. Usually to my right, defense counsel would ask you questions after the questions I ask you. However, as you can see on the screen, defense counsel is the gentleman on the bottom of the screen. Once I'm finished asking you questions, he will ask you questions. As you see the judge up there. If the judge or defense objects or stops, just stop talking, and then we'll resume when Your Honor indicates for us to resume. Okay? Could you please restate your name for the record?
Brianna Womack.
Brianna, I want to take you back to the day of July 25th, 2019. Do you recall that day, miss?
Yeah.
Okay. Were you at the location of 17568 Sorrento Street, City of Detroit, in the County of Wayne?
Yes.
Could you please tell us what's at this location?
My son's grandmother.
Could you speak a little louder?
My son's grandmother lives there.
Okay. On this day, Miss, do you recall who was at your son's grandmother's house when you arrived there?
Yes.
Who do you think who was there?
My son's grandmother and his two aunts.
Okay. While you were at your son's grandmother's home on that day, did something happen that brings you to court today, miss?
Yes, ma'am.
What was that?
An altercation that happened with my vehicle.
Okay. There's an altercation with your vehicle. Was the person involved with that altercation? Is that person, would you be able to identify that person?
Yes.
Okay. Is that person in the courtroom or on Zoom today?
Yes, on Zoom.
Okay. Could you please tell us, based on Zoom, if you can tell what the person is wearing?
The hoodie, yellow hoodie.
Your Honor, may the record reflect the identification of the defendant, Tony Mitchum, please?
The record will reflect.
Thank you. Brianna, could you tell us who's the defendant to you?
He's my son's father.
He's your son's father? Okay, so let's start with the beginning. Prior to this incident, this altercation, as you indicated, that happened with your vehicle. When did you first observe the defendant on that day?
I observed him when he came over after I was already there at his mother's house.
Okay, he came to
his mom's house.
Okay, and what did you observe? Anything after he arrived to his mother's home?
I mean, his mother got into an altercation.
Okay. Was it a verbal altercation or physical altercation?
Verbal.
A verbal altercation? What was the altercation about?
He just stated, why I was there and, me not to be there.
Okay. So the altercation was because you were present, you were visiting her?
Correct.
Okay. So after, tell us, describe, the defendant's behavior, during this, altercation with his mother?
He was upset, agitated, just yelling, saying that he would pack his stuff and leave.
Objection. Hearsay.
Hearsay, he's the defendant.
It's not an admission.
Objections overruled. Continue.
Thank you. What were you doing, during this altercation that the defendant was having with his mother?
I was sitting on a couch next to her holding my baby.
Okay. Can you tell us, when this altercation ended, what, if anything, did the defendant do?
He went outside with his things that he had packed, and he walked up to my car and he kicked in my doors on the driver's side.
What kind of vehicle do you have, miss?
I have a Toyota RAV4 2011.
Okay. And you said, so is that a four-door vehicle?
Correct.
Okay. And then you said he kicked in the doors on which side?
The driver's side and then the passenger side behind it, so two doors.
Two doors. Okay.
Both
on the
located on the left side.
Thank you. So both on the driver's, the front and the back door.
Correct.
Okay. Were you observing this while he was doing this?
Yes, I was looking out the window to see if he would do anything, and he did.
Okay. Did anyone else participate in this, the damaging of your vehicle besides the defendant?
No, just the defendant.
Okay. And were the police called in regard to this, damage to your vehicle?
Yes.
Did the police come to the location?
Yes.
That location?
Yes, they did.
You tell the police?
Okay, one second. What is, okay. Okay, if you're not speaking, can you stay on mute? There's a lot of noise coming right now. I'm not sure if that's coming from the courtroom or from someone else, but please mute yourself. Thank you. Continue, Madam Prosecutor.
Thank you, Your Honor. Did you tell the police officers what you observed happened to your vehicle?
Yes.
Did you witness the police officers observe your vehicle?
Yes.
Did they take a police report?
Yes, they did.
Did you tell them who you observed do the damage to your vehicle?
Yes, I did.
Can you please tell us what damage resulted from the defendant hitting your two doors? What, if any, damage happened?
Both of the doors on the driver and passenger side on the left, created huge dents that couldn't be repaired. So I was told that I had to get two new doors.
Okay. Did you go and get an estimate?
Yes,
for
ma'am.
that?
Objection. Hearsay on the, she was told that she needed two new doors. There's no, there's no identification of who said that, let alone there being, it's hearsay.
Argument, response rather.
Your Honor, I'm happy to follow up with that question in regards to that, providing an estimate as people's
Okay.
proposed exhibit one.
Objection sustained. Continue.
Did you obtain an estimate for the damages that resulted from this incident that the defendant damaged your vehicle?
Yes, I did.
Do you recall where you received that estimate from?
Yes, Suburban, Toyota, out in Farmington Hills. I got an estimate at the repair shop.
Okay, do you recall roughly how much the damages, the estimate was for?
$1,300.
Your Honor, since defense is not here for me to preliminary show them the estimate, May I approach the witness? I do have in my hand, People's Proposed Exhibit 1, the damage repair estimate that we're discussing.
Yes.
Thank you. Brianna, you can hold that for a moment. To review that, and could you tell the court what I just handed you?
A paper of the estimate.
Does that appear to be a fair and accurate copy of the estimate that you received for the two driver's side doors being damaged?
Correct.
Has the copy that I gave you been altered in any way from the original that you received?
No.
Your Honor, the people move to admit People's Proposed Exhibit 1, the damage repair estimate into evidence, please.
Any objection?
I object on the grounds that it's not authenticated, Your Honor. And that there's nobody here to authenticate it.
There's no one here from Suburban Toyota to authenticate the estimate that they wrote up and sent and gave to the witness.
But they allegedly wrote up and sent and gave to the witness, yes.
Your Honor, the witness has indicated prior to my handing her the estimate where she received estimate, which is Suburban. The estimate is from Suburban. The authentication is that her receipt of this estimate, she personally received it from them. We don't normally have the people who come in, who give the estimate come into for preliminary exam purposes, Your Honor.
Objections overruled.
Thank you, Your Honor. Brianna, can you look down at that estimate? Can you confirm where the estimate indicates it's from?
Suburban Collision in Farmington Hills.
And what is the date on this estimate? Charmaine, maybe at the top portion of it. Sorry, we can skip that question. We'll have it published for later, that's not a problem. Your Honor, moving on for time purposes here. Does the estimate indicate what vehicle this estimate is for?
Yes.
Okay, and what vehicle is that?
Toyota RAV4 limited automatic 4-wheel drive 4-door.
Okay. And not to read off everything, I know that's a very long estimate indicating the details, but could you tell us on the estimate, what parts of the vehicle does the estimate actually list cost descriptions for?
My front door and my rear door.
Okay. And what is the total estimated amount to repair the front door and rear door damage that was incurred?
$3,136.76.
Your Honor, I apologize you're not here. People would ask permission to publish to the court.
Absolutely.
Copy for you. Thank you.
Permission granted.
Thank you. No further questions at this time, Your Honor. Thank you.
Cross.
Good morning, Ms. Womack. Did you provide any photographs to the police of the vehicle?
Yes.
You did? Did you provide photographs of the vehicle prior to that day to the police?
Can you kind of help me understand the question?
Did you provide any photographs of the vehicle without the damage to the police?
I don't believe so.
That house that you were visiting is where Mr. Mitchum resided at the time, correct?
Yes,
And what was your purpose for going there?
to visit my son's grandmother.
Do you have a relationship with your son's grandmother that goes beyond that that association?
The defendant and I used to date, so yes,
Are you friends with her?
no,
Did you know that the defendant was there when you went over there?
Objection, Your Honor. I believe that during direct, we heard that the witness indicated that she was there prior to the defendant coming. So
What is your legal objection, counsel? No, Madam Prosecutor, what is the objection that you're making?
And, Excuse me now, Your Honor, what my legal objection is on this line of questioning. I'll withdraw the objection.
Okay, continue. Restate the question again, counsel.
Ms. Womack, you, at the time, you knew or had reason to know that Mr. Mitchum would be there when you visited the house.
no, I did not know.
Did you have a dating relationship with Mr. Mitchum at the time that you visited the house?
No,
And you did know that that was his primary place of residence at the time, correct?
no, I didn't.
I have no further questions, Your Honor.
Redirect.
No further questions, Your Honor.
Ma'am, you may step down from the witness stand. Call your next witness.
No further witnesses from the people, Your Honor.
Any witnesses on behalf of the defense?
No witnesses, Your Honor.
Okay, argument.
Thank you, Your Honor. People move that defendant Tony Ethan Mitchum be bound over on count one, malicious destruction of personal property, 1,000 or more, but less than 20,000. As the witness, Brianna Womack, testified on the date of July 25th at her child's grandmother's home, which is at 17568 Sorrento Street in the city of Detroit, County of Wayne. She observed the defendant, after getting into a verbal altercation with his mother, go outside and physically damage both her driver's door and her driver's side passenger rear door of her Toyota RAV. Officers were called on the scene, as the testimony indicated, to the witness testified to observing the officers, observe the damage on the vehicle, take the police report, and afterwards an estimate was provided that was placed into record as proposed exhibit 1 on People's Proposed Exhibit 1, the estimate from Suburban, which indicates that the damage that the defendant did to the witness's Toyota RAV was over $3,000. As far as the vehicle prior to or thereafter, that would be a question of fact or a trier of fact. But at this time, people believe that probable cause has been met and ask that the defendant be bound over on count one. Thank you, Your Honor.
Argument. Defense.
Your Honor, this is an incredibly thin case. There are no pictures involved of the vehicle. There is nobody to there's been no testimony offered into evidence of whether the damage to the vehicle was created or caused by any actions by Mr. Mitchum. I think that there's a missing link in the elements here, which is that the damage was caused by Mr. Mitchum. And I would ask that the court dismiss the case.
Court haven't heard the arguments of counsel as well as the testimony. The court finds that probable cause does exist. Therefore, the defendant will be bound over to the Wayne County Circuit Court for further proceedings. The arraignment on the information will be when?
Yes, Your Honor, that would be February the 9th at 9 a.m.
Is there anything that we can do about that at this stage, Your Honor? I'm in Hawaii
No.
that day.
Well, first of all, congratulations. And no, but you can definitely contact the circuit court and tell them of your, your plight of being in Hawaii while we're dealing with 7 inches of snow, and you'll get what you get for that. So, but again, all right. Thank you very
Good
much.
to see you, Judge.
Yes, indeed.
Thank you,
Have a
Ms.
good
Merrick.
day.
Have a great day.
All right. All right. Anything else ready, Madam Clerk? All right. All right.
If you guys have a few moments, I'm gonna go outside and see which witnesses we have on our next exams, as well as defense counsel, and I'll be right back in.
Okay, we'll take a 7-minute recess. We'll be right back. All right. All righty. Serena, are we ready on anything?
Yes, Your Honor, on a waiver for Jalen Johnson, Tony Wallace is here.
Okay, please call it.
Case number 2261100. The people of the state of Michigan versus Jalen Johnson. The defendant is charged with count 1, weapons carrying concealed.
Okay. Madam Prosecutor.
Good morning, Your Honor. Daniela Parrish on behalf of the people, P85495.
Good morning, Your Honor. Good morning to your staff. Ted Wallace, P80922, on behalf of Mr. Johnson, who's present in court, standing right behind me.
Okay. All right, today's date and time set for exam is my understanding that your client wishes to waive his right to a preliminary examination.
That's correct, Your Honor. I've
Okay.
heard him and I have talked. I've told him that he has the right to an examination, but after
All right, Mr. Wallace, bring him up next to you if you don't have an objection to it. So I
Okay.
can see it. Okay. All right, sir, state your name for the record.
Jalen Henry Johnson.
Okay, sir, do you understand that you have a statutory right to a preliminary examination by which the people would have to prove that the felony offense charge was committed in the city of Detroit and that there's probable cause that you committed the offense? By waiving this examination, the exam will not be held and you'll be bound over to the Wayne County Circuit Court for further proceedings. Do you wish to waive this examination?
Yes, sir.
You gotta speak up, sir.
Yes, Your Honor.
Did anyone force you or make any promises to induce this waiver?
No.
Are you doing so freely and voluntarily?
Yes.
Okay. Court finds that the waiver was freely and voluntarily executed. Therefore, the defendant will be bound over to the Wayne County Circuit Court for further proceedings. The arraignment on the information will be
February 9th at 9 a.m.
okay. Good luck, sir.
Thank you, Your Honor.
All right.
Sir, that's it.
Are the parties here on John Timmons?
We're getting now, Your Honor.
One more time.
We're getting them now, Your Honor, out of the hallway.
Okay, thank you.
I was going to help with the missions change.
Okay, well, safe trip.
Thank you.
Enjoy the weather, if nothing else. Okay. All right.
Stand right here in front of the yellow circle, sir. Play the code there.
Serena, get everyone in place. I have to call Judge McClinton very quickly.
Okay, Judge.
Thank you.
No problem. To see you on camera.
Yes. Mr. Timmons, Don Timmons.
You're fine. Have everyone in place?
Yes, we're doing an action.
Okay.
Yeah.
Madam Clerk, the judge know they're ready. He took a call from a different, he took a call, he's taking a call. He should be back. Okay, sorry. Oh, that's okay.
Okay, Madam Clerk, please call the next case.
Yes, Your Honor. Case number 22060800. The people of the state of Michigan versus John Oliver Timmons III. The defendant is charged with count 1, assault with intent to murder, count 2, assault with intent to do great bodily harm less than murder or by strangulation. Count 3, assault with a dangerous weapon, felonious assault. Count 4 and 5, weapons, felony firearm. Count 6, weapons, felony firearm.
Good morning, Your Honor. Daniela Parrish on behalf of the people, P85495.
Good morning, Judge. Neighborhood Defender Service by Glen Oak, P83424, appearing on behalf of Mr. Timmons.
Sir, state your name for the record.
Yes, my name is John Oliver Timmons III.
Okay. Madam Prosecutor?
Thank you, Your Honor. I have been speaking with defense counsel prior to us going on the record and have explained in detail what has transpired. The people are moving for a very brief adjournment. Defense has agreed to stipulate to a brief adjournment. When I say brief, like next 7 days. Reason for this is at the PCC, when subpoenas are supposed to go out, they never went out. I did catch this error yesterday. I tried to rectify it by sending out self-made subpoenas to the OIC. Unfortunately, on such short notice, the OIC, who is in the courtroom today, was unable to serve those subpoenas. I explained the situation, no fault to the witnesses. They have no notice that this exam was even set for today. I was not the prosecutor at PCC, so I do not have a valid reason as to why these subpoenas did not go out. I'm assuming this was just a clerical error of some sort, but defense has agreed to stipulate to a brief adjournment so that we can at least get notice out to the witnesses. If they do not appear after receiving that notice, obviously at that time, what will be, what will be.
Attorney O?
That's correct, Judge. Defense is stipulating to a very brief adjournment of this case.
Okay. Madam Clerk, pick a date and time.
The next available dates are that February 13th date at 10 a.m.
Madam Clerk, do we have anything that we could just?
Let me check the
Anything next week, Thursday or Friday?
Thursday or Friday, so that would be.
I don't mean to, I just don't want to hold it up. So February 13th is the earliest.
Let's see, Judge Shabri. Let me just double check. She has something for 9. That's for February 2nd, I'm sorry. And then for the 3rd, for February 3rd, she has something scheduled for every 15 minutes there.
But we could do February 13th.
February 13th.
That works for the court.
Sorry about that. I don't mean to delay it. Whatever.
Yeah, I mean, but yeah, the issue is that the court is the court is not anticipating exams that are scheduled not going, and so the docket has been pretty packed going forward. So I didn't think there was a lot of wiggle room for Judge Sabri left dates that were available for adjournments, and the February 13th date was the first date that. So what time on the 13th?
At 10 a.m., Your Honor.
Okay, thank you very much.
Thank you.
Sir, can we return? I'm sorry.
That was 10 minutes. Okay, are we ready? Are we ready on Gregory Johnson?
Judge McConico, Officer Carson, on the
I'm sorry.
10:30 Johnson, we have the Attorney Young here, and she's waiting on her client, and we don't have any witnesses or anything checked in, Judge.
Okay. Okay, thank you very much.
And then we have a witness on the Trimble matter. Ms. Young checked in on the 10:30.
Okay.
And then on the 11 o'clock, we just have a witness. Okay.
Madam Clerk,
Yes, Your Honor.
just a quick check-in. Anything?
Let me check with Madam Prosecutor. I don't.
We didn't have, well,
Ms. Young's client is not here, Your Honor. She will be here in just a second.
we're waiting on defendant to
Thank
arrive.
you.
Okay, thank you, guys.
Sure.
And how about, let's see, what is the other one? What, any word on Trimble and Martinez?
Your Honor, Tremble, the people offered the defendant a plea. Defense reached out to me last night, indicated that they will be accepting the plea, so that exam should not be going. And they indicated that they would send over the signed plea to the court. If they do not, I do have a copy if Your Honor wants to, if they decide to zoom in, if Your Honor wants to sign on their behalf.
Okay. All right, what about the Martinez Aurelia case? Any word on that?
Martinez, Your Honor.
Okay. All right, no problem.
Johnson, the Johnson one, defense counsel is standing here with me. We're just deciding if it's going to be a KPS or a dismissal. None of our witnesses are here yet, Your Honor.
Well, that's a big difference.
I know, right?
Good morning, Your Honor. Rita Young, appearing on behalf of Mr. Gregory Johnson. I've been communicating with him. He had problems with his battery in his vehicle. And the last time I talked to him, he said he was on his way now. So please, can we just have another 10, 15 minutes?
Yeah, no, I'm just doing a house cleaning. It's you know, we started some of the other stuff late, so I'm not gonna cape you some yet. So yeah,
Okay.
we're good. We're good. All right. All right. Madam Clerk.
Yes.
Send me, I'm going to step into something else right now. Send me a text when something is ready.
Okay, I will do that.
Okay, but keep badgering all the parties to get here. So do my annoying thing that I'm doing right now. So keep it up. All right.
What's your person's name?
What? Are we ready on, let's see, on the Johnson matter?
Yes, Your Honor.
Sir, here, sir.
Serena, please call the case.
Yes, Judge. Calling 2261061, the people of the state of Michigan versus Gregory Johnson, the defendant is charged with count 1, weapons carrying concealed, count 2, weapons, firearms possession by felon, count 3, weapons, felony firearms, second offense. Defendant is present to the next courtroom.
Madam Prosecutor.
Good morning, Daniela Parrish on behalf of people, PA 5495.
And good morning, Your Honor. May it please the Honorable Court, reading on P44626, appearing on behalf of Mr. Gregory Johnson, who is present and standing to my right. We are ready to proceed.
Okay, Madam Prosecutor.
My apologies, Your Honor. People are unable to proceed at this time, or subpoenaed witnesses have failed to appear.
Move for dismissal, Your Honor.
Matter will be dismissed without prejudice.
Thank you so very much. By counsel.
I'm sorry. I didn't hear you. Counsel?
Oh, fine, Your Honor. I was asking him if he has a personal recognizance bond, so never mind.
Okay. Thank you.
Thank you.
All right, sir, wait for your attorney outside, don't run off, I got paperwork for you.
Thank you, Madam. You're welcome. Thank you, Madam Prosecutor.
No problem. You have a nice day. Thank you.
So.
Thank you.
Yeah, British. I'm not sure how. British, there were witnesses, I said, to you think of it. My understanding that there.
Hey.
Two. I think him up on a. Man was gonna.
No,
Right. So, but.
Hello,
state your name, sir.
Jerome Trimble.
Okay. Thank you. You can place yourself on mute.
I haven't had extensive conversation.
Yes.
Have any officers
Madam Clerk,
Yes, Judge Laconico?
are we ready on Trimble?
Judge, I do.
Your Honor, I believe Mr. Trumbull, the defendant, is on Zoom.
Yes, he
However,
is.
Defense counsel contacted the clerk indicating that he was double booked. He was in an exam in Westland. I did indicate that we kind of have a short docket today and hoping that he could zoom in so that we could resolve this quickly. He did not indicate to the court clerk when we could zoom in. Madam Clerk, do you think we could give him a call to see if he could zoom in quickly so that we can get this taken care of?
Sure, I'll try to give him a call back.
Thank you, Madam Prosecutor.
I believe, Madam Clerk, we do have the signed plea agreement as well, right? So that we can move forward once you could pretty quickly.
Yes, I have it. Okay.
It's pretty annoying, so let's see what the client said. I mean, I was hoping you'd get here early enough for me to go over
Yeah.
it.
Okay, thank you.
I know. Right, and I.
So I would.
Yeah, I felt that.
Yes, sir. We offered a plea on that. Because the plea wasn't.
Attorney Martin, what case are you here on?
Good morning, Judge. I'm here on Jerome Trumbull.
Madam Clerk, please call the Trimble case.
Yes, Your Honor, calling case number 2261066. People of the state of Michigan, Jerome Trumbull. The defendant is charged with one count of larceny in a building.
Okay. Madam Prosecutor.
Morning, Your Honor. Daniela Parrish on behalf of the people, P85495.
Good morning, Your Honor. Neighborhood Defender Service of Detroit, Carrie Martin, P84592, appearing on behalf of Mr. Jerome Trumbull. Mr. Trumbull, would you please state your full name for the record?
Take yourself off mute, sir. Oh, looks like he may be frozen. Mr. Trumbull, can you hear us? Mr. Trumbull, you just put yourself back on mute. And he's gone. All right. He'll be right back. So, Madam Prosecutor, what are we doing right now?
Your Honor, all of our witnesses have appeared. People are ready to go for it. However, have offered a settlement offer to defense counsel prior to today, a dismissal of the first part in a building, and with the defendant agreeing to alternatively count two larceny, a misdemeanor larceny of 200 or more, but less than 1,000, which will also be taken under advisement. I believe that the defendant is back on the record. Shall I proceed, Your Honor, to tell you what the terms?
Yes, yes.
I'm here now. I'm sorry about that.
Wait, state your name for the record, sir.
Jerome Trimble.
Okay. Right now, Mr. Trimble, it's my understanding, there is an offer to a reduced plea to a misdemeanor. Is that what you wish to do?
Yes, sir.
Okay. And is my understanding also, Madam Prosecutor and Counsel, that there's a signed plea? There's a signed plea agreement.
Yes, 1 year.
No, sir. I'm speaking to your counsel right now.
Yes, there is a sign. I do have a signed plea agreement from Mr. Trimble. I did just want to go on the record first and clarify the court's position as to diversion. I had discussed misdemeanor diversion with Madam Prosecutor, and I know sometimes with the diversion, there's not a formal plea entered or a plea agreement submitted to the court, but it's, the case is just put into diversion without an acceptance of a guilty plea, and after the completion of the diversion conditions, it's dismissed. But I just wanted to.
That is traditionally with the CCW cases when there was a diversion program. I'm unaware of that on other types of felony cases, and so with this matter, there would be an allocution to the facts, and the case would be dismissed if Mr. Trimble complies with all of his conditions in a year.
Very well. Okay, and now, go ahead.
As I needed to the defense counsel, and I apologize, and I did give an updated settlement offer that does take the word diversion out of the terms and conditions, because technically this would be not deemed diversion, but taken under advisement.
That is correct.
Yes.
That is, and one second, Madam Prosecutor, and that's what I was gonna say. The diversion program was a program dealing with gun cases. Other matters they're taken under advisement, whether it's 7411, 769, or whatever, and then the matter is dismissed. So it's not a diversion; it is taken under advisement for a term and then dismissed.
I understand, and thank you. We will proceed with the allocution and taking the case under advisement.
Okay.
Your Honor, the terms and conditions that are mentioned in the settlement offer is a 1-year probation with an alcohol assessment. And treatment is determined by that assessment as needed. No contact with the complainant, which is Hollywood Casino, and any other terms and conditions set by the court, including fines and costs. And no objections to advisement, which dismissal of the case upon successful completion of the terms.
Okay, Mr. Trimble, please keep try to mute your phone until we need you to speak. Is that your understanding, Mr. Martin, of the terms and conditions?
Yes, that's my understanding as well. And the background noise is probably more on my end. I'm at the district court in Westlands. So apologies for that.
Okay.
Yes.
And Madam Clerk, one quick question. When cases are taken under advisement, does Judge Sabri normally go to immediate sentencing or wait to come back for sentencing?
Judge, from my understanding, this is being reduced to a misdemeanor, right, Madam Prosecutor?
Yes,
This
when
case
it's
would
reduced
be.
to a misdemeanor, usually Judge Brian does the sentencing.
Exactly.
I'm sorry, one more time.
When it is reduced to a misdemeanor, Your Honor, we do the plea on the record, and it is.
And it goes to Judge Bryant. Yeah, okay. Listen, I haven't done this in a while, so I'm a little rusty. All right, sorry about that. All right, let's get it going now. Mr. Trimble, take yourself off of mute.
Yes, sir.
Okay, who's gonna make out the factual basis?
Defense?
Yes, I'll do it. And if I miss anything, please let me know. Mr. Trimble, I'm just gonna ask you a few questions. Give me one moment.
Yes, sir.
On December 24th, 2022, were you in the area of the Hollywood Greektown Casino?
Yes, sir.
And that's in the city of Detroit in the county of Wayne.
Yes.
And did you take an item from the casino without permission?
Yes.
And is that item worth less than $1,000?
Yes.
That's all I had, Ms. Parrish. Is there anything else that you'd like to get on there?
No, people are satisfied. Thank you.
All right, the court is as well satisfied. The plea was freely and voluntarily made. Madam Clerk, a sentencing date.
That date will be February 21st at 9 a.m.
Okay, thank you.
Thank you.
All right, good luck, sir.
Thank you.
Yes, sir.
And Mr. Martin, you sent that over to the court, the signed, or do you need Judge McConaughey to have it signed for you?
I'll do that right now. Thank you, Ms.
Thank you.
Parrish. I can just send it to Judge Sabri's court email.
Yes, yes.
Yes.
I will do that right now.
If you don't mind.
Yes, I'll
Thank you.
CC you. Thank you.
All right, and last but not least, is what? Martinez Aurelia. Are we ready on the last case?
No, Your Honor.
Okay.
Ken Reagan, PA 2125 on behalf of Mr. Javier Martinez Arroyo. My apologies, Your Honor. I just heard from my client about 10 minutes ago. He was having difficulty in securing a ride.
Okay, one second. Madam Clerk, please call the case.
Yes, Your Honor. Calling case number 22060. 23101, the people of the state of Michigan versus Javier Martinez Arroyo. The defendant is charged with 1 count of weapons carrying concealed, count 2 weapons, firearms, brandishing in public.
Morning, Your Honor. Daniela Parrish on behalf of the people, P85495.
And good morning, Your Honor. Good morning to your staff. Neighborhood Defender Services by Ken Reagan, P82125 on behalf of Mr. Javier Martinez Arroyo.
Okay. Counsel?
Your Honor, my apologies. This matter was set for 11:15. About 10 minutes ago or so, I received a call from my client stating that he was having some difficulty securing a ride. He said he was waiting on his ride. Said he lives approximately 5 to 10 minutes away. So he's on his way. I just asked for a brief adjournment, or I'm sorry, not adjournment. I've just asked for a brief delay so that my client can get here.
Your Honor, the people's witnesses are not here either, therefore we have no objections if it's okay with the court to wait a few more minutes for the defendant to arrive. And we
Yes.
could, similar to the other case, text
No
you.
problem. Yes.
Again.
Yes, no problem. All right, I'm here. Let me know.
Thank you.
Okay. Madam Clerk,
Yes, Your Honor.
can you send me in the chat the phone number to the courtroom? Well, Madam Clerk, I didn't think that was that, I didn't think that would be an issue. Would you prefer that I contact you another way?
It's fine. Whichever way is fine.
I'm just joking with you, Serena. I'm just joking. Hold on. All right. No.
All right.
Ms. Boyd, is my understanding we're ready on the last case for the morning?
Judge, I do believe the defense counsel, the client is he en route or disclosed,
He
sir?
actually said he was in front of the building, so I expect him to walk into the room before he.
Okay, no problem. Okay, no problem. Call the case, Madam Clerk. Oops, call the case, please. Madam Clerk, can you hear me?
I'm sorry, Judge, the courtroom was on mute. I'll recall it again. Calling
Okay.
case number 2260231, the people of the state of Michigan versus Javier Martinez Arello. The defendant is charged with count 1, weapons, firearms brandishing in public, count 2, weapons carrying concealed.
Good morning, Your Honor. Daniela Parrish on behalf of the people, P85495.
And good morning, Your Honor. Good morning to your staff. Neighborhood Defender Services by Ken Riggin, P82125, on behalf of Mr. Javier Martinez Arello, who stands with me to my right.
Sir, state your name for the record.
Javier Martinez Arreola.
Okay. Madam Prosecutor?
Your Honor, my apologies. Our subpoenaed necessary witness failed to appear. OIC is here, indicated that the subpoenaed officers had a last minute training event, therefore were unable to appear.
Your Honor, I do not find that as good cause. This matter, according to Madam Prosecutor File, was scheduled on January 6th. I believe they should have been served subpoenas to this matter. I don't believe that going to a training supersedes coming to a preliminary exam that was previously scheduled. I ask that we dismiss this matter without prejudice.
Okay. Court does not, while training's obviously very important, we would like all of our officers to have proper training so that they can stay safe as well as protect and serve the citizens of Detroit. A subpoena is just that, it's a subpoena, and that is not good cause to not be here today. Therefore, the case will be dismissed without prejudice.
Thank you.
Thank you. Madam Clerk,
Yes, Your Honor.
are there any other matters? I'm working off of memory on cases right now. Are there any other morning matters?
No, Judge. No,
Okay.
that's it.
All right. Thank you very much. Thank you, Madam Reporter. Thank you, Madam Prosecutor. See you guys a little later.
All right, thank you.
Oh, Madam Clerk, you may be stuck with me tomorrow. I got some updates.
Okay, that's fine.
Yeah, she's moved upstairs at Frank Murphy, so.
I've been there, Judge. It's fine.
Yeah, that's what I'm trying to say. Listen, jury duty is a wonderful thing. That's civic duty.
Yes, it is.
I didn't think you judges could would pass the.
Oh, absolutely. No. Judges get seated all the time. Judge Baltimore is very funny. He gets picked constantly to sit, and